Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyer. Josh Whitaker and Joe Hamer of Whitaker and Hamer Law Firm, managing partners there, practicing attorneys here in the great state of North Carolina. Offices conveniently located Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. And folks, I'm Morgan Patrick, consumer advocate. We get into legalese each and every week, and we have a little fun along the way, but it's very serious discussion. And this next one, guys, it's all over the news.
Yeah, Morgan, the Dodd case, and this is one we spent a whole show talking about the opinion when it leaked and what it would mean. And obviously, the final opinion came out. It was very similar to the leaked opinion. They added a concurring opinion from Justice Thomas, and then there were the dissenting opinion, which I think Breyer wrote that opinion. So we got the full opinion. We had a chance to read it. It's been, of course, widely reported on. It's a big case. It's a case we'll be talking about for years and years and years. And the fallout from it is not over. Joe, you might remember facts on the Dodd case. This is one where we had an abortion clinic suing a state. I can't remember. I think it was Mississippi. I don't have the facts in front of me, but they had a law. They passed a state law saying, you couldn't get abortion after 15 weeks. That is in violation of Roe v. Wade, in direct violation. And so this case went to the Supreme Court, and so that's what was presented by the Supreme Court. And the Supreme Court, I don't know that we would have predicted this one. I thought that the court was going to limit abortion, but here, 5-4 decision, they reversed Roe v. Wade. And Joe, we've talked about how the Roe v. Wade and the cases after it used this substantive due process in the Constitution and kind of created this right, or read into the Constitution, this right of privacy. And this logic has been used in a lot of cases. Roe v. Wade, until recently, was the biggest example. But this got me thinking, and I read some opinion pieces in different newspapers. But we started talking about textualism. Say that for me.
Textualism.
Yeah. So reading
substantive.
Reading the Constitution verbatim, right? Just looking at the words not reading anything into it, just looking at the Constitution and taking it at face level, and not try to read anything else into it. But, this right of privacy that got created and was used in Roe v. Wade, the court doesn't like it, right? It's not a good way. The court has shown that it's not going to use that same rationale, at least this court.
That's right, Josh. And, you go back and you reference the fact that we talked about this. I think we talked about this a few times before the actual decision came down. We talked about it pre-leak. We talked about it post-leak. And you referenced the fact that you don't think we really predicted it would go this way. I'm going to just conveniently ignore that and pretend like it never happened.
Right.
I can't recall our exact prediction, but I don't think we hit it on the nose, if anything. I'm going to be very vague and say we got close.
Well, I don't think we made an official prediction.
That's right. We did not.
Right. Yeah.
Yeah. We generally will avoid an official prediction when we when we just don't know, and I don't think we knew here. I think we knew something was going to occur, but I think it's safe to say we probably didn't anticipate it rising to the level that it rose to, and such a drastic change and harsh critique and just complete slapping down of that Roe v. Wade ruling. And you mentioned the substantive due process and how that's been used in several cases. It's been a principle that's been applied numerous times, and the court here is almost forcing you to look back at every case that's used it the way that they're analyzing that concept.
Yeah. Again, we go out of our way to be non-political. That's not the point of our time here. But I do feel like at times I have to just be honest. And so I'm not here to say abortion's right or wrong. That's not up for me to decide. But I do agree a lot with the court, on, the Constitution is the Constitution. It's not a very long document. It's not, certainly there's some things that are up for debate in it, how to interpret certain clauses and, where a certain comma comes in and what that means. So you can do that kind of stuff all day. But in the end, we're left with the writing. And I've always been one where, something says what it says and we can interpret it a little, but I've never been a big fan of reading rights, into the Constitution or saying, well, the founders would have done this, or I think we can take this clause and it means this. And so what the court did here, or the way I read the opinion, is the court said this reasoning is flawed. When you read the Constitution, there's no enumerated constitutional right to abortion. And I think what the court did here is that reasoning is not good. We're not going to continue with it. We think it was erroneous at the time. We think it's still erroneous. It's still wrong. We're going to correct it now. Better late than never. And so that's where we got into the conversation about stare decisis and precedent, and what does that do to the court when they ignore settled law? And here they didn't care. They were like, well, we don't like it. We never liked it. And here it is. But I think this is important. And I've seen this reported, like abortion's not illegal on a federal level. That's not what the Supreme Court did. They said, there's no constitutional right to abortion. We're not legislators. You're duly elected legislators. They're the ones who need to take this up and decide. And of course, they haven't, right? There's been no action legislatively to, the Congress could easily just say, hey, abortion's legal. Here's the statute. Doesn't matter what the states do. But that hasn't happened. So now we're left, every state's left up to itself. And you've seen how that goes. You've got states all across the board.
Yeah. And, you mentioned that, Josh, the fact that this is, it's not an outright prohibition of abortion. And I think again, you get into the kind of the echo chamber of social media, and you get into a lot of the real partisan way that news is presented. And I'd be willing to bet that there's a lot of folks really fired up that just aren't adequately informed about the issue, and probably do assume that, this ruling outlaws abortion completely. I would not be surprised if there's a decent chunk of the population that thinks that, when again, that's not the case. Like you said, it's not federally illegal. And it could easily be legislated, and there could be a law that's passed that says, this is something that can be done across the board. And that's not something that's being prevented in any manner, but I haven't seen any real movement on that front as far as on a federal level. But like you said, we've seen widely varying approaches to this state by state, which is to be understood because, different states have different demographics and different ideals and different ideologies. And so you're going to see a kind of a widely varying approach to this.
Yeah, so you've seen some states. New York is undertaking amending their constitution. I don't know the process, and I haven't read the story, but looks like maybe they've got the votes necessary to amend the constitution of their state to include abortion as a constitutional right. You've seen states like Texas and some other southern states kind of already had laws on the books, right? If Roe v. Wade is ever overturned, abortion is illegal. You've seen some states. There's a big story about a girl in Ohio who sounds like maybe had been raped, very young girl, was trying to get an abortion, missed a 6-week deadline that I guess is on the books. I think it was Ohio. I didn't read a lot of it, but had to go to a different state. And you see a lot of states who are trying to find ways to penalize people who go out of state to get abortion. So it's like the Wild West in abortion law right now. There's not even anything close to uniformity, and that. Honestly, from a attorney perspective, that's the biggest problem is, how is it going to be treated in different states? And it really, it's just going to be wide open, until something's done on the federal level. And I think that's what everybody is either super happy with the Supreme Court, decision, or they're really angry about it. There's not a lot of people who are middle of the road on this issue. But those, your elected representatives can make, depending on what side you fall on, they can make this right, or, I just don't see where it's not a very smooth path forward, I think is the best way to say it right now.
It's a very rocky path forward, Josh, I think is the best way to describe it. And, very, very interesting. The way that this critique of that substantive due process, you could really read that into some other precedents, like you mentioned in your notes here, and the fact that that was basically called demonstrably erroneous, and that there's a duty to correct the error established in those precedents. That's strong wording being used there.
Yeah, that was from the Thomas dissent. So Justice Alito wrote the main opinion, and is the one you might remember went through all the history of how abortion has been treated in the United States, and went on to say that this doesn't necessarily affect other rights that we've read in, because you can same-sex marriage, other reproductive rights that have used the same logic to say we have a constitutional right that this is protected. Alito says the court's not coming after these other things, but this is before them and they want to correct it. But in Thomas's dissent, he specifically says, we should look at all this other stuff now, and this is our chance to fix all this stuff based on flawed constitutional logic. But I don't know, Joe. I don't want, people are going to be talking about this for a long time. I mean, we're years and years and years. We're going to see the way this decision affects everything around us.
That's right, and it'll be interesting to see how it develops. I'm going to go ahead and refrain from making any further bold predictions, but it'll be very, very interesting to see how this progresses, how this plays out, and what kind of the ripple effects of it are.
There you have it, folks. The Outlaw Lawyer, again, a very delicate subject to talk about. It is top of the headlines in the news. Again, the Dodd abortion law fallout. It will be back on the show from time to time, I know, as it continues to be a hot button issue. You are listening to The Outlaw Lawyers, Josh Whitaker and Joe Hamer. You can find them at Whitaker and Hamer Law Firm. And we want to thank you for listening. I tell you, we've kind of got our niche on the weekends and talking about the legalese. And if you've got a situation that you are facing and you just have questions that you need answers to, jot this number down and call it 800-659-1186. That's 800-659-1186. And just leave your contact information, briefly what the call's about, and an attorney will return that call shortly. And also, you can always email your questions to the program, questions@theoutlawlawyer.com. We'll use those questions on a future show. We'll change the names around, but you know what? You'll get an answer to your question that way as well. And check out the website, theoutlawlawyer.com. We've got more coming up on the program today. Next up, New York State Rifle and Pistol Association versus the Bruen decision. That's coming up next on The Outlaw Lawyer.